Hi, everyone. It's David O'Dea with O'Dea Schneider PLLC. Today, we're talking about the military offense of conspiracy as defined under Article 81 of the UCMJ. This charge is one of the most commonly used in military courts, and there's a reason for that. It's broad, strategic, and often used to link multiple people to a single plan, even if not all of them carried it out directly. Under the UCMJ, conspiracy has two essential elements. First, that two or more people entered into an agreement to commit an offense punishable under the UCMJ. Second, that at least one of them took an overt act in furtherance of the conspiracy. The offense itself doesn't have to be completed. In fact, even if the plan completely falls apart, the conspiracy can still be charged. And that's because the agreement, paired with some act to move that plan forward, is considered a crime on its own. So, what exactly is an overt act? Well, the military judge's bench book in the UCMJ makes it clear that it doesn't have to be an illegal act in itself. An overt act is simply any step taken to help carry out the plan. That could be sending a message, gathering supplies, or showing up at a planned location. The act just needs to indicate that the agreement was being put into motion. It doesn't take much, just enough to demonstrate that this wasn't just talk, but a real attempt to commit the underlying offense. Now, prosecutors use conspiracy charges because it gives the prosecutors a wide net. It allows the prosecutor to reach beyond the person who physically committed the crime and hold others accountable, anyone who agreed to the plan and did something to help. That could mean helping coordinate, offering tools, or just passing along information to advance the offense. It also allows for the use of what's called co-conspirator statements to be admitted in court, which can make conspiracy cases especially powerful for the government. But there are limits. The prosecution must still prove the object of the conspiracy. The thing the group intended to do would have been an actual offense under the UCMJ. If the alleged plan doesn't involve a criminal act, then the conspiracy charge cannot stand, even if everyone involved fully intended to go through with it. Now let's talk about some common defenses. First, no agreement. Just being there, overhearing a conversation, or knowing that something is happening isn't enough. There has to be a clear and voluntary agreement to participate. Second, no overt act. If no one took a concrete step to move the plan forward, even if a real agreement takes place, that may not meet the threshold. Third, withdrawal. If someone pulls out of the conspiracy before the overt act occurs and clearly communicates that withdrawal to others, that individual may avoid criminal liability for the conspiracy. But these defenses hinge on timing, intent, and details. Courts will look closely at what was said, what actions were taken, and whether the person's involvement crossed the line from passive knowledge to active participation. It's also worth noting that a person who withdraws after the overt act occurs may still be guilty of conspiracy, even if they later distance themselves from the crime. That's why timing and communication are critical in evaluating whether the defense of withdrawal applies. Conspiracies can be very serious charges, even when the underlying offense never happens. It's all about the agreement, the steps taken to carry it out, and the intent behind it. Understanding how this works is essential to evaluating how the charge fits into a broader case. As always, this video is for informational purposes only. For questions about a specific situation, it's important to always consult someone who's familiar with military justice and the UCMJ process. Thanks for watching.